Several clients have recently asked me, what is an NDA or what is a confidentiality agreement and what's the difference? So NDA stands for non-disclosure agreement. A confidentiality agreement is almost the same thing with a different label. The three things that I think are very important in the context of putting NDAs in place is the following. First, who are you disclosing to and who's doing most of the disclosure? For example, if you're disclosing it to a marketing team who's going to market your idea, that's a different audience than if you're disclosing it to someone who is technically aware of your field and you're trying to get their input on how to improve or make your product, or you're disclosing it to someone who potentially might want to buy the product. Again, it's important to understand who your audience is that you're disclosing content to, because that's going to determine what goes into the agreement. Whether you label it a confidentiality agreement or a non-disclosure agreement, I think, the end result is the same. You're trying to prevent someone from being public in the sense of the law for patenting purposes, and you're trying to prevent them from sharing the idea with other people. There are other factors to consider. However, the most important for me is understanding who you're disclosing it to. The second factor that you need to understand and keep in mind is the following. Are you disclosing the idea and expecting feedback from the person? Or are you disclosing idea without any expectation of feedback? For example, if you share your idea with a marketing team, they're probably not going to give you feedback on the idea. They're going to give you feedback on how to market it, what's the best way to do it. On the other hand, if you're sharing your idea with someone who has technical expertise and they're going to give you feedback on things that will improve the idea, it is very important that you remember the agreement must cover that scenario. That's what we call a feedback clause in your non-disclosure or confidentiality agreement. Furthermore, are you disclosing to someone and then expecting them to return all the confidential information you shared with them? And what happens to knowledge they can retain in their memory from their discussions with you? In other words, they've returned all the material to you. They're no longer holding on to anything in written form that's confidential, but their memory is really good and they can remember. Are they allowed to go forward from what they remember and capture improvements on your idea? Because remember, if they come up with improvements on their own, those are patentable concepts and they technically are the inventor. And if you incorporate those improvements in your idea, or if you want to incorporate their improvements in your idea, you need to have a clause that addresses that directly. And one way to do that is through a residual clause. So we have NDAs, who you're disclosing it to, number one. Number two, what is the thing that you're disclosing? Are you expecting feedback? Are you expecting information to be retained by them? And are they allowed to improve based on their memory after they destroy all the confidential information? It is important to have those things addressed in the confidentiality agreement. It's not enough just to say, this is our confidential information and we gave it to you. So you gave it to them, it's confidential, they returned it to you, they destroyed it. But what about the feedback they gave you? What about the memory that they have and things they can retain without reference to your confidential documents or paperwork that you sent them? And the third thing to keep in mind is that confidentiality agreements have to address the issue of duration. How long are they obligated to keep stuff confidential? How much of the information are they going to keep confidential? How will they know the information is confidential? So all of that for me falls under the duration. You identify it, you let them know for how long, and so forth. Those have to be addressed in the confidentiality or non-disclosure agreement. And of course, you can also territorially limit it, which is not a good idea. So who are you talking to? What are you expecting as a return response from it? And how long are they going to keep it confidential? Those are all things that are important to be in a non-disclosure agreement. I've seen too many non-disclosure agreements that don't address the issue of feedback, that don't address the issue of residual information that's retained in memory of a person, or don't address for how long the information has to be kept confidential, or the obligations in terms of destroying, maintaining confidential information. My name is Jubin Dana with Dana Legal Services. Here's our contact info. reach out, give us a call. Happy to answer your questions or help you out with any non-disclosure or confidentiality agreements you have. Take care.